Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
The Good Conduct Time Allowance credits, or GCTA, became controversial a few years back when the public objected to the grant of more time credits to persons deprived of liberty, which would have led to the early release of some PDLs serving time for committing heinous crimes. The implementing rules and regulations were subsequently changed, but the IRR itself was challenged before the Supreme Court. Should PDLs convicted of heinous crimes benefit from more generous GCTA credits? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 20th of December 2024, and today we talk about the case of Narciso B. Guinto et al. Versus Department of Justice et al., decided on April 3, 2024. It's an unbanked decision penned by Supreme Court Associate Justice Maria Filomena D. Singh. And joining us to talk about this case is Attorney Jelcy Di Maano from the Office of Associate Justice Singh. Hi, Attorney Jelcy. Thanks for joining us and welcome to the Supreme Court Podcast.
Good day, Attorney Mike, and to all the listeners of the podcast.
All right, so Attorney Jelcy, let's talk about the factual antecedents that led to this case. First, what is Good Conduct Time Allowance and why did it become an issue prior to the filing of this current petition?
Okay, to start, Good Conduct Time Allowance, as defined under the law, pertains to the privilege granted to an offender which entitles him to a reduction of his or her jail or prison term as a reward for good conduct and exemplary behavior. This takes into account the offender's active involvement in rehabilitation programs, productive participation in authorized work activities or accomplishment of exemplary deeds, and faithful obedience to all prison rules and regulations. And the relevant law in this case is Republic Act Number 10592, which was signed into law in 2013 and amended Articles 29, 94, 97, 98, and 99 of the Revised Penal Code, or the RPC. Thereafter, the first implementing rules and regulations, or the IRR of the law, was issued in 2014, and this 2014 IRR provided for the prospective applicability of RA 10592, but this provision was subsequently invalidated in the case of Inmates of the New Bilibid Prison versus De Lima, decided in June 2019, where the Supreme Court ruled that the GCTA law can be applied retroactively following the doctrine in criminal law that penal laws favorable to the accused should be applied retroactively.
So, Attorney Jelcy, just to unpack some of the things that you mentioned. So, this law, RA 10592, actually gave more time credits to qualified persons deprived of liberty, right? So, the change was that in the first IRR, it was only applied prospectively. But the Supreme Court said, no, you have to also apply it prospectively. Explain to us this concept, this criminal law concept, that if there is a provision in the law that is favorable to the accused, then it must also be applied retroactively. Can you elaborate on this?
Yes, because in this case, since the new law, the Republic Act Number 10592, expanded the scope of the application of GCTA law to include those under preventive imprisonment. These are favorable and advantageous to the accused. So, under the doctrine in criminal law, it should be applied retroactively. So, the provision of providing for prospective applicability was struck down by the Supreme Court in the De Lima case.
And for the benefit of our listeners, this will only apply if it's beneficial to the accused.
Yes.
If it's prejudicial,
Yes,
it won't have any retroactive.
Yes.
Right. So, I understand that in the current petition, there are two sets of petitioners. Can you tell us who they are and why did they file this petition?
Yes, there are two sets of petitioners in this case. The first set of petitioners are on the list of those who were ordered to surrender by the then President Duterte after certificates of discharge from prison were already issued to them. Included in this first set is Narciso Guinto. Narciso Guinto was already released on parole and benefited from the GCTA law, but was ordered rearrested by the then President Duterte. Because when the De Lima case was decided, news broke out around August 2019 that a former Calauan mayor, already convicted of heinous crimes, could benefit from the GCTA law and could lead to his early release. At this time, it was also publicized that nearly 2,000 heinous crimes convicts were already freed because of the GCTA law. It was then that the then former President Duterte made a pronouncement and ordered that these nearly 2,000 freed heinous crime convicts, they were ordered to surrender within 15 days. Otherwise, they could be treated as fugitives. It was also then that the DOJ reviewed the implementation of the GCTA law and then issued the 2019 IRR, the now subject of this case.
What was the change in the 2019 IRR compared to the 2014 IRR?
The 2019 IRR absolutely disqualified persons convicted of heinous crimes from the application of the GCTA law.
And if you're convicted or you're charged with heinous crimes, there was no distinction in the IRR, right?
Yes.
Okay. So, when they filed this petition, what did petitioners want the Supreme Court to do?
They want the Supreme Court to determine whether or not RA 10592 indeed excluded certain convicted prisoners from the application of the GCTA law.
So that includes them, right? Because they were convicted already, they served time, and in fact, they were given certification that they have already finished serving time on account of the additional GCTA credits, but they were ordered rearrested or they surrendered themselves because of the ultimatum.
Yes, that is correct.
So, right. So, essentially, they were asking also for their freedom,
Yes.
right? Right. So, with respect to the 2019 implementing rules and regulations, zero in on what they want. What exactly did they object to that?
As persons convicted of heinous crimes already serving their sentences, they wanted the Supreme Court to declare the provisions of the 2019 IRR insofar as it excludes persons convicted of heinous crimes from the benefits of the GCTA law because they allege that it is beyond what RA 10592 says.
For the benefit of our listeners, let me just read some of the provisions on Good Conduct Time Allowance under the 2019 IRR. So, for instance, Section 1, GCTA during preventive imprisonment. Among those not entitled to any GCTA during preventive imprisonment are PDL charged of heinous crimes. And for Section 2, GCTA during service of sentence. Among those who are not entitled to any GCTA during service of sentence are PDL convicted of heinous crimes. So, in short, whether you're charged or convicted of heinous crimes, you are disqualified from GCTA. And it's not just GCTA. Even under the time allowance for study, teaching, and mentoring, it disqualifies also those who are charged and convicted of heinous crimes. So, in short, Attorney Jelsi, what the 2019 IRR did was to lump together PDLs, or both charged and convicted of heinous crimes, from benefiting from GCA. They are excluded. That's what the 2019 IRR says. So,
Yes.
What's the argument of the petitioners here? Why are they objecting to being included in the exclusion?
The petitioners argue that excluding persons convicted of heinous crimes from the coverage of the GCTA law is beyond what the law says, and it is beyond what the IRR seeks to implement.
So let's define what's a heinous crime. How do you know that a particular crime is considered a heinous crime? Is murder part of it? Is rape part of it? How about robbery, stealing, for example?
As defined under the law, heinous crimes are crimes which are hateful to the senses and which, by reason of their inherent manifest wickedness, atrocity, and perversity, are repugnant and outrageous to the common standards and norms of decency and morality in a just and civilized society. So, to answer your question, Attorney Mike, murder is a heinous crime. Other examples are treason, parricide, rape, plunder, infanticide, among others.
In fact, there's an enumeration of that
Yes.
in one of the laws that was passed, right? So, is there a difference, though, between a person charged with a heinous crime and a person convicted of heinous crime. For the purpose of this discussion, is there a difference between a person charged with a heinous crime and a person convicted of a heinous crime?
Yes, Attorney Mike, there is a stark difference. A person merely charged with a heinous crime is only accused at this point of doing the said crime and is detained only under preventive imprisonment, while a person convicted of heinous crime is one who is already adjudged to be guilty of committing the heinous crime and will be serving his sentence.
Now, for the purpose of this petition, how relevant is the distinction between the two?
It is important to know the difference between those charged and those convicted because RA 10592 is clear that persons charged with heinous crime is excluded to avail the benefits of the GCTA law under preventive imprisonment. No such distinction exists for those convicted of heinous crimes.
So just to be very clear, under RA 10592, there is a distinction in the treatment of persons charged of heinous crime, while there's no distinction for those who are convicted, regardless of the kind of crimes.
Yes.
So it's relevant because if you're charged with a heinous crime, you cannot qualify for GCTA under the preventive imprisonment part of the GCTA, whereas if you're convicted, you're supposed to benefit under RA 10592.
Yes.
But how did the IRR change this distinction?
The IRR changed this distinction when they expressly included persons convicted of heinous crimes under the enumeration of those who are not entitled to it during GCTA, during service of their sentence.
So IR excluded persons convicted of heinous crimes from benefiting from the GCTA. But for us to understand everything, let's backtrack a bit. Under the original Article 97 of the Revised Penal Code, what did it say? And how was this changed by RA 10592?
Before it was amended, Article 97 of the Revised Penal Code only mentions the good conduct of any prisoner in any penal institution which shall entitle him to deductions from the period of his sentence. After its amendment, it now enumerates two categories. The good conduct of 1, any offender qualified for credit for preventive imprisonment pursuant to Article 29 of the RPC or emphasis on the word or, 2, of any convicted prisoner in any penal institution, rehabilitation or detention center, or any other local jail.
So the first part, when you say you are qualified, who are qualified? Does that exclude persons who are charged with heinous crimes?
After the amendment, there was no distinction as to the convicted prisoner.
Yes.
But there was a qualification with respect to the offender qualified for credit for preventive imprisonment because there is a provision pursuant to Article 29 of the RPC.
What does that
As
article
amended.
say?
The Article 29 of the RPC, there is explicit provision that stated that recidivists, habitual delinquents, escapees, and those persons charged with heinous crimes are excluded from the application of the said section, article.
So persons charged with heinous crimes are not qualified under RA 10592, right? So how did the 2019 IRR differ from the provision of RA 1592, amending Article 97 of the Revised Penal Code?
As mentioned earlier, the 2019 IRR absolutely disqualified persons convicted of heinous crimes from earning GCTA credits.
All right. So how did the Supreme Court resolve this issue?
So the Supreme Court ruled that the DOJ, in issuing the 2019 IRR, exceeded its power of subordinate legislation when it excluded persons convicted of heinous crimes from the benefits of the GCTA law, since Article 97, as amended, did not contain any qualification as to the applicability of the GCTA law with respect to convicted prisoners. Article 97, as amended, used the conjunction or to separate the two categories entitled to GCTA. Otherwise stated, the law is clear either number one, any offender qualified for credit for preventive imprisonment under Article 29 of the RPC as amended, or two, any convicted prisoner in any penal institution, rehabilitation, or detention center, or in any other local jail made avail of the benefits granted by RA 10592.
So, just to be clear to our listeners, who then are entitled to earn good conduct time allowance credits? I think this case sums up and clarifies who are qualified and who are not qualified.
Yes, we have to distinguish. During preventive imprisonment, all offenders who are not recidivists, habitual delinquents, escapees, and charged with heinous crimes are entitled to earn GCTA credits. On the other hand, if a prisoner is already convicted, any convicted prisoner may earn GCTA credits regardless if they are recidivists, habitual delinquents, escapees, or convicted of heinous crimes, so long as they are in any penal institution, rehabilitation, or detention center, or any local jail.
And we've been hearing these words, recidivist, habitual delinquents. Can we define for our audience what does a recidivist mean and who are habitual delinquents?
Yes. These are terms that are familiar with the law students and lawyers who are listening to the podcast. So, recidivists under the law are defined as persons who, at the time of their trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of the RPC. On the other hand, habitual delinquents are persons who, within a period of 10 years from the date of release from prison or last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa, and falsification, is found guilty of any of the said crimes a third time or oftener.
All right, that should be clear. Now, just to close our discussion, Attorney Jelsi, what's our main takeaway from this case?
So, to reiterate, the main takeaway is that any convicted prisoner, regardless of the crime committed, even if it is a heinous crime, is entitled to the benefits of the GCTA law, so long as they are in any penal institution, rehabilitation, or detention center, or any local jail. This carries out the philosophy behind our correctional system, which seeks the reformation of prisoners and allows them another opportunity to become contributing members of the society.
All right. So, thank you so much, Attorney Jelsi, for joining us today.
Thank you, Attorney Mike.
And
to
if you
PAO.
Right. And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search Narciso B. Guinto et al. Versus Department of Justice et al. GR number 249027, April 3, 2024. Here's Steph Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week. The Supreme Court reiterated that premarital sexual relations leading to pregnancy are not immoral and do not justify suspending an employee. The SC ruled that Bohol Wisdom School, a Christian school, illegally suspended a grade school teacher for becoming pregnant outside marriage. The SC held that sexual relations between two unmarried consenting adults are not immoral. No law prohibits this, nor does it go against any fundamental state policy found in the Constitution. The SC clarified that under the law, the standard of morality applicable to all is public and secular, not religious. Public and secular morality refers to conduct that is prohibited due to its harmful effects on human society rather than being based on religious beliefs. The SC held that if the government were to otherwise base public policies and morals on religious beliefs, this would require everyone to conform to a religious program or agenda. As the teacher's pregnancy cannot be considered immoral, it was not a valid ground for her suspension. In another decision, the Supreme Court dismissed Judge Ateneones S. Bacale, presiding judge of the Municipal Circuit Trial Court of Biliran, Cabocgayan, Biliran, for manipulating the procurement of medical supplies for the city of Manila. Under the new Code of Judicial Conduct, judges must act in a way that reaffirms public trust in the courts and should avoid any behavior that could seem improper. Judges can be held responsible for gross misconduct if they deliberately do wrong. The SC found that Bacale ignored the rules on judicial conduct, raising doubts about his integrity and sense of propriety. Bacale admitted that he knew his wife was illegally influencing the bidding for medical supplies. He took part in this by acting as her bagman and received the bidding documents and money from Magaoay. The court thus found Bacale guilty of gross misconduct and ordered his dismissal from the service. The Supreme Court en banc, through the office of the 2025 Sharia Bar Chairperson, Associate Justice Antonio Tico Jr., issued Bar Matter No. 5067, revising the qualifications for Sharia Bar candidates. Under Bar Matter No. 5067, the following need not undergo the 60-day Sharia training seminar. First, those with bachelor's or postgraduate degree in Islamic Studies or Islamic Law from an accredited academic institution. Second, those who completed academic credits in the 4 core subjects for the training seminar, namely, letter A, Jurisprudence and Customary Laws or Fiqh and Adat, letter B, Persons, Family Relations and Property, letter C, Succession, Wills or Adjudication, and Settlement of Estates, and letter D, Procedure in Sharia Courts from an accredited Philippine law school. And third, those with a bachelor or professional degree in law from an accredited academic institution with academic credits in the same 4 core subjects. To read the full text of Bar Matter No. 5067, visit the Supreme Court website. The Office of the 2025 Bar Chairperson, Associate Justice Amici Lazaro Javier, issued Bar Bulletin No. 2, Series of 2025, dated December 16, 2024, on the application requirements and venue assignment procedure for the 2025 bar examinations. The online application for the 2025 bar through the Barista platform is from January 8, 2025 until March 17, 2025. Visit the Supreme Court website to read the full text of the Bar Bulletin. And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Irania as researcher, Victor Laranio, Don Ryan Balza as sound editors, and Tyke Flores and Jerome Batumalake as web editors.